I didn't even know my 750-acre farm had been sold until a stranger tried to lock my own gate. Let that sink in. 750 acres. My grandfather's land. Generations of crops, cattle, irrigation lines, and one long gravel road cutting through the valley. And according to the paperwork I was handed that morning, it no longer belonged to me. The man at the gate wasn't aggressive. He was confused. He said he just closed on Phase 3 expansion from the HOA development next door. He showed me a subdivision plat map. My farm was shaded in blue, labeled, Future Residential Parcel, Acquired. Acquired. That word hit harder than anything else, because I never signed anything, never attended a sale, never received a certified notice. Nothing. The HOA next door had been trying for years to expand. They built luxury homes along my northern fence line and constantly complained about tractors, livestock, and early morning irrigation pumps. They wanted a cohesive community aesthetic. I wanted to be left alone. Apparently, that wasn't good enough. By noon, I was sitting in my attorney's office staring at documents filed at the county recorder's office. There it was, a transfer deed showing my property conveyed to an LLC connected to the HOA's president.
Signed.
Not by me, but notarized. Which meant one thing: forgery, or fraud so bold it barely tried to hide itself. My attorney immediately flagged multiple red alerts. No verified service of foreclosure. No tax delinquency filings. No court-ordered petition. No eminent domain authority. In other words, they had zero legal path to sell anything. Yet somehow lots were already being marketed inside my eastern pasture. Bulldozers were staged near the creek. And a coming soon, luxury estates banner was hanging on my fence. That's when I understood their play. They weren't betting on legality. They were betting on speed. If they could build fast enough, sell enough homes, and create enough third-party ownership chaos, undoing it would become impractical. They thought I'd settle. They thought I'd take a payout. They thought 750 acres was too big to defend. They were wrong. But here's where it gets worse. When we pulled HOA board meeting minutes through a public records request, we found something buried in an executive session summary. Strategic acquisition completed. Completed. Before I even knew it started. The HOA president had quietly formed a development shell company 6 months earlier. That same company now held a deed, my deed, filed with the county. My signature forged. My property listed as transferred through a distressed owner conveyance.
Distressed?
I had 0 liens. 0 missed taxes. 0 debt against the farm. They manufactured distress, then created paperwork to solve it. It was audacious. And it was criminal. So we did what any rational landowner would do. We called the sheriff. Not to make a scene. Not to escalate. But to document. When deputies arrived, I calmly explained that active construction equipment was staged on land still legally titled in my name. I showed them certified copies of the original deed chain dating back to my grandfather. They examined the recorded transfer. One deputy muttered, "This doesn't smell right." That was the first crack in their illusion. Because here's what the HOA didn't realize. I had something they didn't account for. Leverage. Not political leverage. Not social leverage. Legal leverage. Because if they wanted to play paperwork games, I was about to show them how ownership really works. And by the time this was over, they wouldn't just regret trying to take my farm. They'd regret ever learning my name. The first thing we did wasn't sue.
It was smarter than that.
We froze everything. My attorney filed an emergency motion for a lease pendens against the entire 750-acre parcel. That single filing did one critical thing. It put the world on notice. Any buyer, any bank, any title company, if you touch this land, you inherit a lawsuit. Within 24 hours, 3 pending home sales inside the future residential expansion collapsed. Lenders backed out. Title insurers refused to issue policies. The HOA president thought speed would protect her. Instead, speed exposed her. Now, construction crews were still parked near my creek, but nobody was moving dirt. Nobody wanted to be the contractor caught building on contested property. That's when we dug deeper into the forged deed. The notary stamp looked legitimate at first glance, but the commission number? Expired. By 2 years. The distressed owner conveyance affidavit referenced a statute that didn't even apply to agricultural land.
Sloppy.
Confident criminals make sloppy mistakes. Then we found the real fracture point. The legal description attached to the transfer deed didn't match the recorded boundaries from the original plat. It included acreage that overlapped the HOA's own entrance road.
Meaning?
In trying to steal my land, they accidentally transferred land that wasn't even properly described. That kind of defect isn't cosmetic. It's fatal. We filed a quiet title action the next morning. And that's when the phone started ringing. First, a developer who had put down a deposit on 12 lots. Then, a couple who thought they were buying their forever home. Then, a regional bank demanding clarification on collateral risk. The HOA president had marketed homes before verifying ownership. That's not just aggressive development. That's misrepresentation. By the end of the week, the sheriff's office had opened a fraud investigation. Because once a forged signature enters county records, it stops being a civil dispute. It becomes criminal. But here's where the story pivots. While reviewing the HOA's financial disclosures, which we subpoenaed, we discovered something shocking. They had already taken non-refundable deposits from 27 families, collected infrastructure fees, even pre-sold utilities access tied to my irrigation easements. They weren't just planning to build. They were monetizing land they didn't own. And then my attorney leaned back in his chair and asked me one question. Do you want to defend or do you want to counter? That's when I remembered something critical. Years ago, when the HOA first formed, they needed access across a narrow strip of my property for emergency vehicle routing. I granted a limited easement, recorded and specific. Temporary. Revocable if misused. Guess what they just did? They misused it. The entire Phase 3 staging area relied on that easement for construction traffic. Without it, no access. No building materials. No development. So we sent a certified notice. Easement revoked due to material breach and fraudulent activity. Effective immediately. Within 48 hours, concrete trucks were turned around at the road. Framing materials sat idle. Workers stood at a locked gate. The HOA president called me directly for the first time. She didn't threaten. She didn't posture. She asked what I wanted. I told her the same thing I wanted from the beginning. My land. My title cleared. A public retraction. And full financial accountability. She said I was overreacting. That we could work something out. But here's the thing about forged deeds and illegal sales. Once police are involved, working something out isn't simple. And when we filed our amended complaint, adding fraud, conspiracy, slander of title, and tortious interference, the damages number crossed 8 figures. Because this wasn't just about acreage anymore. It was about every buyer misled. Every contractor misinformed. Every dollar collected under false ownership. The HOA thought they could rewrite reality with paperwork. But paperwork cuts both ways. By the 3rd week, the HOA wasn't just nervous. They were exposed. The fraud investigation was active. The lease pendants had frozen their expansion. Deposits were being demanded back. Contractors were threatening breach of contract claims. But I wasn't done. Because while my attorney prepared for trial, I made a discovery that shifted the entire battlefield. It started with a routine title sweep. If they were bold enough to fabricate a transfer of my 750 acres, what else were they sloppy about? So we ordered full title reports, not just on my land, on theirs. And that's when the domino tipped. The HOA itself did not technically own several of the common area parcels inside their development. Those parcels were still titled under the original developer entity, which had dissolved 5 years earlier.
Meaning?
The HOA had been maintaining, leasing, and representing ownership of property it never legally received, including the clubhouse parcel, 2 retention ponds, the community park, and most critically, the entrance monument lot. That monument lot carried their signage, utilities hub, and security gate infrastructure. And on paper, it wasn't properly conveyed. Now here's where it gets interesting. When a developer entity dissolves without properly transferring property, the remaining assets don't magically vanish. They become subject to claims. And because I was now an active litigant uncovering fraudulent conveyances involving the same network of shell companies, my attorney saw opportunity. The dissolved developer entity still had an open administrative reinstatement window. So we petitioned the state to revive it. Legally. Quietly. And once reinstated, we acquired controlling interest through outstanding creditor claims tied to infrastructure easements the HOA had breached during their attempted farm grab. In simple terms, they played paperwork games. So we played them better. Within days, we held legal standing over the entity that technically retained title to the entrance monument parcel and adjacent common infrastructure, which meant one thing: control. We didn't storm in. We didn't make a spectacle. We sent notice. Formal.
Precise.
Effective immediately. Access and use of Parcel 14A, entrance monument lot, required written authorization from its managing entity,
which was now controlled by me.
At first, they ignored it. Then utilities flagged the ownership discrepancy during routine compliance verification. Then the security company requested proof of authority to maintain the gate. Then insurance carriers asked uncomfortable questions. The HOA president showed up at my attorney's office the next morning. This time, no arrogance. Just panic. She accused me of retaliation. My lawyer calmly slid certified copies of the reinstatement paperwork across the table. All filings lawful. All interests recorded. She realized what had happened. The same loophole strategy she attempted on my land had just boomeranged. But I wasn't trying to steal anything. I was trying to force reality back into alignment. So I made her an offer. Release all fraudulent claims on my 750 acres. Publicly acknowledge the forged conveyance. Rescind all Phase 3 contracts. Cover investigative and legal costs. In exchange, I would transfer control of the monument parcel back under properly documented governance. She hesitated. Because admitting fraud isn't just expensive. It's dangerous. Police were already reviewing the notary irregularities. Buyers were consulting attorneys. Board members were distancing themselves. And now, for the first time, the HOA couldn't even confidently claim ownership of its own front gate. That afternoon, squad cars pulled into the development not for me. For document collection. Search warrant authorized. Forgery isn't a civil misunderstanding. It's criminal. Neighbors watched officers walk into the HOA office and leave with boxes. The illusion of control shattered in broad daylight. But here's the part nobody expected. Instead of escalating, I scheduled a public meeting. Open invitation. Homeowners only. Because this was never about destroying a neighborhood. It was about exposing a board that treated land like leverage. The HOA thought the police showing up was the climax. It wasn't. It was the beginning. Because 3 nights later, over 120 homeowners packed into the high school auditorium for the emergency community meeting I requested. Not an HOA board meeting. A homeowner meeting. Open floor. Recorded. Transparent. The HOA president sat at the front table with what remained of her board. Their attorney was there. 2 uniformed deputies stood along the back wall, not for intimidation, but because an active fraud investigation tends to require presence. I didn't bring anger. I brought documents. When I stepped to the microphone, I didn't accuse anyone of theft. I projected the county records on a screen. Original deed chain, my farm. Forged transfer filing, time-stamped. Expired notary commission, highlighted. Recorded lease pendens, active. Reinstated developer entity, lawful. And then I asked the room a single question. Did any of you know your deposits were tied to land still legally titled in my name? Silence. One couple raised their hands slowly. They had already wired $80,000 toward a Phase 3 build. A contractor stood up and admitted he'd been told ownership was clean. Another homeowner asked why they were only hearing about this now. The HOA president tried to speak, framing it as a legal dispute under review. But one deputy stepped forward when voices rose and calmly reminded everyone, there is an active criminal investigation into recorded documents. That word, criminal, shifted the air. Because civil lawsuits are messy, criminal charges are serious. Then my attorney explained the real exposure. If the forged deed was confirmed, every contract tied to Phase 3 could be void. Every deposit subject to clawback. Every misrepresentation potentially personal liability for board members who signed disclosures. Homeowners started asking different questions. Not, why is he fighting the HOA? But, why were we never told the title wasn't verified? That's when the fracture became visible. 2 board members publicly stated they had relied on documentation provided by the president and had not independently verified the transfer. One admitted they were told speed was essential before opposition mobilized. Opposition. That was me. Except I never opposed growth. I opposed fraud. Then came the moment she lost the room. A homeowner asked directly, did you sign off on the Phase 3 marketing before confirming ownership? She hesitated. That hesitation answered everything. The deputies didn't arrest anyone that night. They didn't need to, because reputational collapse is quieter and often more devastating. Within 72 hours, a recall petition circulated. 61% of homeowners signed. Emergency board elections were scheduled. Meanwhile, the district attorney's office formally requested sworn statements from board members involved in approving the transfer documents. The notary, whose expired commission was used, located, interviewed. Turns out, she hadn't notarized anything. Her seal had been digitally replicated. Forgery just escalated to identity misuse. And when that report hit the HOA's insurer, coverage was suspended pending outcome. No defense funding. No shield. Just personal exposure. That's when settlement talks resumed, not with arrogance, but with urgency. They offered to rescind all Phase 3 claims, issue written acknowledgement of invalid transfer, reimburse legal costs, and cooperate fully with investigators. But I added one more condition. Public disclosure to every homeowner explaining exactly what happened. Transparency isn't revenge. It's accountability. The new interim board agreed. And for the first time since this started, I saw something different in that room. Not fear. Relief. Because the community realized something critical. This was never farmer versus neighborhood. It was truth versus manipulation. The charges came on a Tuesday morning. Not with sirens. Not with flashing lights. But with paperwork. The district attorney filed formal counts of felony forgery, filing false instruments, and fraudulent conveyance related to the recorded deed transferring my 750-acre farm. It wasn't dramatic. It was methodical. And that's what made it devastating. The HOA president turned herself in that afternoon with council present. No perp walk. No spectacle. Just a booking photo that quietly circulated through the county clerk's system. For the neighborhood, that was the moment it became real. This wasn't a miscommunication. It wasn't a clerical oversight. It wasn't aggressive development. It was criminal fraud. Meanwhile, the civil case moved just as efficiently. Under court supervision, the HOA executed a full rescission of the fraudulent deed. The county recorder expunged the invalid transfer from public records. The lease pendens was lifted not because I lost, but because I won. Clear title restored. Chain of ownership reaffirmed. 750 acres. Untouched.
Permanent.
But it didn't end there. The buyers who had placed deposits in Phase 3 were refunded in full from emergency HOA reserves. The association levied a special assessment to cover shortfalls, and homeowners, now fully informed, voted to pursue recovery directly from former board members responsible for the scheme. Civil indemnification flipped direction. Instead of the HOA protecting leadership faced personal contribution claims. Insurance denied intentional fraud coverage. Defense fees became private. Board members who once signed expansion resolutions confidently were now signing sworn affidavits, distancing themselves from the forged filing. The notary identity misuse added another layer. Digital forensic reports traced the replicated seal to a document workstation inside the HOA administrative office. That detail alone dismantled any remaining doubt. There would be no quiet settlement buried under non-disclosure. There would be a record. As for the monument parcel and developer entity I temporarily controlled, I transferred it back, cleanly, properly, transparently, under newly elected leadership, with updated conveyance documents filed and verified in open session. No tricks. No leverage. Just structure restored. At the final civil hearing, the judge summarized it plainly. This case demonstrates that recorded property rights are not suggestions. They are foundations. Attempts to bypass them will be met with full consequence. Damages were awarded for legal costs, investigative expenses, slander of title, and economic interference. Significant. But the money was never the headline. The precedent was. Because here's what changed permanently. Every title company in the region now double verifies HOA-related expansion filings. County clerks flagged internal audit triggers for large agricultural transfers. Developers now require independent landowner confirmation before marketing expansion lots. And inside that neighborhood, homeowners attend meetings. They request disclosures. They read financial statements. Governance became participation, not blind trust. As for me, the farm is quieter now. The coming soon banner is gone. The bulldozers never returned. Cattle graze where Phase 3 was supposed to rise. And the gate, the same one that stranger tried to lock months ago, still swings open under my name. They thought speed would protect them. They thought complexity would exhaust me. They thought paperwork could rewrite ownership. But ownership isn't a rumor. It isn't a strategy. It isn't a marketing plan. It's law. And law, when properly used, doesn't need revenge. It needs documentation. 750 acres.
Still mine.
And this time, untouchable.